against the order of the Central Information Commission. So the Supreme Court becomes the litigant and the Supreme Court also becomes the judge. And they passed a stay order, staying the order of the Central Information Commission. And now they have referred that matter to a constitution bench so that it will be enforced for the next 15-20 years. So for the next 15-20 years, you will not get any information about appointments of judges, about how appointments are taking place. And this is another problem that we have about in the judiciary. That there is just no transparency about how the judiciary functions, how they make appointments to Class 3, Class 4 employees, how they make appointments of judges, what their assets are, even on their asset disclosure case. In that case, what was the information sought? Information sought was, are judges filing their asset declaration to the Chief Justice or not? This was all the information. He did not seek, Mr. Subhash Agarwal, who made that application, did not seek the actual asset disclosure. He only said, are they disclosing their assets to the Chief Justice or not? Even this information was denied. Central Information Commission said you have to give this information. You have asked some kind of issued some code of conduct under which these asset declarations have to be made to the Chief Justice. Therefore, you certainly know whether these declarations are being made or not. Please disclose whether the declarations are being made or not. Against that, they appealed before the High Court. High Court, single judge, dismissed the appeal and held that you have to give this information. Against that, they filed an appeal before the division bench of the High Court. Chief Justice A.P. Shah constituted a full bench of 3 judges. Again, the full bench of 3 judges said that you have to give this information. They went up in appeal before the Supreme Court, and the matter is pending in the Supreme Court. Another matter that during this time, they made asset declarations of those judges public at that point of time. But thereafter, they have removed those declarations from the website and nobody knows what's happening with the new judges either, whether they are making asset declarations or not. So, we have a situation about the judiciary where you can't take any action, disciplinary action against judges. You can't even register FIRs against judges. You can't even publicly disclose any evidence of corruption or misconduct about judges because you run the risk of contempt. And you cannot even seek any information about judges under the Right to Information Act. I mean, effectively you can't do that. Coming to appointment of judges. See, prior to 1993, appointments were being made by the government in consultation with the Chief Justice of India. That's what the Constitution says. Appointments of judges shall be made by the President in consultation with the Chief Justice of India. 1993, they gave a judgment that in order to preserve the independence of the judiciary, it is essential that the judiciary must control judicial appointments. And therefore, appointments made by the President in consultation with the Chief Justice of India must be interpreted to mean appointments will be made by the Chief Justice of India in consultation with the President. And therefore, they took charge of appointment, of judicial appointment. Now it is true that prior to that, judicial appointments were being made by the government often for political consideration. So if the Congress party was in power, well, usually the Congress party has been in power. There was only an interview of 2 years in between by that time. when the Janata Party was in power, and at that time I don't think that appointments were being made on political considerations, because at that time appointments had been left essentially to the Chief Justice. Whatever the Chief Justice was recommending was being done. But it is true that during the Congress regime, appointments were being made on political consideration. But what has happened subsequently? Subsequently, after the court took over charge of appointments, we find that appointments are now being made on nepotistic consideration. Recently, in the Times of India, there was an article about how a particular judge of the Supreme Court, who is now in the Supreme Court, Justice Sarok, appointed Justice Balakrishna's brother-in-law as a judge of the Kerala High Court when he was Chief Justice of Kerala, and immediately after that, Justice Balakrishnan appointed Justice Sarok to the Supreme Court, brought him to the Supreme Court, and he will be one of our future justices. Same way, Justice Mitchell, when he was Chief Justice here, recommended the appointment of the sister of Justice Kapil, Justice Shukla Kapil. She was appointed as judge of the Calcutta High Court, and immediately after that, Justice Mitchell was appointed to the Supreme Court. What we are seeing is, because in the present system of appointment, there is no method laid down. There is not even any criteria laid down as to how judges shall be selected. If you ask any Chief Justice today, how do you select judges? He will say, well, we look at competence and we look at integrity. So if you ask them, well, you think these two criteria are enough? What about judicial temperament? Judicial temperament is an important quality for a judge. That is, a person should have the ability and the willingness to hear both parties dispassionately and then make up his mind rather than come with a free mind. There are many judges who are very competent. Justice Karti is one of them. Very competent judge, very honest judge also. But completely lacks judicial temperament. So therefore, why do you not look at judicial temperament? And what about whether that judge subscribes to the directive principles of state policy or not? Does he believe in the directive principles of state policy? Does he understand and adhere to the basic principles of the Constitution? Do you look at that or not? Or do you just look at some kind of textbook competence of the judge? So, they will say, well, we never thought of this. Or, no, we look at this also. But you ask them, how did you look at this? What is the manner in which you examine these things? Have you ever written out somewhere what is the criteria on which you will appoint judges? They will say, no, not necessarily. So, no criteria has been laid down. No system has been laid down for judging people on that criteria. And judges are being appointed purely or largely on nepotistic considerations. Occasionally, when there are some good Chief Justices, they don't appoint them on nepotistic considerations. But because in the absence of a system, they are not able to find out who are the best judges. Because unless you have a proper system laid out, in which you will go through all the available people, you will systematically try and analyze what are the qualities that they have, what are the qualities that you need, what are the qualities that they have, to what degree. Until then, you will end up in an arbitrary method of making appointments. And that is what has been happening. That is why we have been saying again for a very long time that you need an independent full-time body, you may call it the Judicial Appointment Commission, which must have the authority to appoint judges, select judges, and which should do it in a proper systematic manner by laying down a criteria. That criteria should be finalized after public consultation, by laying down a method of judging people across that criteria, by laying down a method of shortlisting candidates, and doing it transparently. All this should be done transparently. One of the best safeguards against arbitrariness in appointment is transparency. If everybody can see who are the candidates who have been shortlisted, and people have an opportunity to point out that look, this particular candidate did this, which makes him unfit, or this particular candidate did this, which makes him particularly fit, or whatever. All that should be allowed and enabled. In the absence of this, appointment will continue to be arbitrary. So, these are the broad problems. I was talking about my own contempt case. So what happened was, in that interview with the NLK, I was asked, so why did you get involved in this campaign for judicial accountability? I said, look, in my 27 years of practice, I have seen a lot of corruption in the judiciary. In fact, in my view, about half of the last 16-17 chief justices were corrupt. I told you I said that because I wanted to also drive home the point that corruption is not merely restricted to the lower judiciary, it is also equally there in the higher judiciary. At the end of the interview, I was asked about whether there are other ways of other ways in which corruption manifests itself in the judiciary. I said yes, there are many. One of them, for example, is the manner in which the present Chief Justice, 16th Kapil dealt with this Vedant case. I said that look, he had shares in this company. Here he proceeded to hear with this case and deal with this case, and he passed a very peculiar order when he said that Vedant can't be given this leave because it has been blacklisted by the Norwegian government, but its subsidiary Sterlite can be given this leave, and he had shares in Sterlite. And he eventually ordered the giving of the leave to Sterlite. Of course, I have clarified thereafter when contempt notice was issued. Eventually, when Mr. Hari Salve, who styled himself as amicus curiae in that case, he filed an application for contempt against me, citing these two passages, saying that both these are contemptuous. Contempt notice was issued. I filed affidavit explaining what I said, why I said it. I said, so far as this issue of corruption in the judiciary is concerned, corruption among the Chief Justice is concerned, that is my perception. And that's my honest and bona fide perception. And that perception is based on some documentary evidence, some oral evidence of some retired Chief Justices and senior advocates whose information and opinion I trust, and on the basis of some circumstantial evidence. On the basis of all this evidence, you form a certain perception of who's corrupt, who's honest, etc. And I have only voiced my honest perception. And in a democracy, every citizen should have the right to voice his honest perception, because unless he can do that, you can't have a free and frank debate about the state of affairs in the judiciary, and thereby you will not be able to decide what needs to be done to correct the state of affairs. So that's so far as that is concerned. And about the party, I explained that I am not accused him of any kind of financial corruption. I only said that look, he had a conflict of interest in this case, and he ought not to have dealt with this case. And on top of that, he went on to pass an order which I consider unconscionable. However, I regard him to be a judge of absolute financial integrity, and I have great regard for his integrity and his character. But anyway, they have decided to continue the proceedings, so they will continue. We don't know what will happen, but whatever happens, the point is that all this needs to be changed. There is no reason for the Contempt of Court Act to have this clause must be deleted from the definition of criminal contempt. It is enough for you to say causing any interference or obstruction in the administration of justice. So if you cause an obstruction, that is, for example, recently this Bar Council Chairman, Tamil Nadu Bar Council Chairman, one man called Chandra, he went to the court of a judge of Chennai, Justice, what's his name? Anyway, he went to the chamber of one of the judges of Chennai and told him that, look, my client must be granted bail by you. That his bail case is coming up tomorrow before you, and you must grant him bail. And this Union Minister, Mr. A. Raja, he wants to talk to you. He is interested in getting bail to this person. Please talk to him. And he handed him a mobile phone. That judge said that this is most improper. I am not going to talk to him. You should know that this is most improper and you will get out. Next day, when the matter came up in court, this man started shouting at the chairman of the Bar Council, Chandra. So that judge wrote a letter to the Chief Justice of the High Court, Justice Boktrita, complaining against Chandra and saying that you take whatever appropriate action you feel against this gentleman. Justice Gokhale wrote to the Chief Justice of India, Justice Balakrishnan, about this. Balakrishnan, when he was asked about this, he concealed the name of the A. Raja in order to protect him. But thereafter, one lawyer filed a petition against Chandra Mohan with the Chennai High Court, and the division bench of the Chennai High Court nearly passed an order to the effect that the disciplinary proceedings, the complaint against Chandra Mohan pending before the Bar Council of Tamil Nadu shall be withdrawn and tried by the Bar Council of India. And till such time that the Bar Council of India decides that, his membership of the Bar Council shall remain suspended. Against this order, see, the High Court passed a very mild order against him. They should have straight away sent him to jail for contempt. What he did was gross contempt, interference with the administration of justice, trying to influence and overall judge. That is certainly contempt. But even this order has been stayed by the Supreme Court. They don't feel that this is a serious contempt, trying to overall intimidate, influence a judge into giving a particular order by going to the chamber and saying that a minister is interested. This is not serious. But if somebody says that in my view half of the last 16, 17 Chief Justices have been corrupt, that according to them is a very serious interference with because this whole jurisdiction of contempt, unfortunately, has been used by the judiciary not really to protect the administration of justice, but to protect themselves. This is what has happened. It's been misused and abused, and that is why we have been saying that this part of the definition of criminal contempt must be deleted. That is scandalizing the court or lowering the authority of the court from the definition of contempt. The other part, that is interfering with the administration of justice, that can remain, and that is enough to protect the administration of justice. So this is essentially all that I want to say about judiciary and judicial transparency and judicial accountability, and I'll be happy to answer any questions or